good morning, good afternoon, and good evening to everyone, dependent where you are, of course. And welcome to another week of our Global Cafe sessions. My name is Roxana, and I'm very excited to be introducing you all to Mr. Bryan Gilmartin for the topic of the prevention of financial abuse of older adults, a very important topic. And just to give everyone a little bit of a background on Bryan, he is a partner at WEL Partners in Toronto, Ontario, where he practices exclusively in the area of wills, trusts, estates, powers of attorney, guardianship, and capacity related litigation. Since 2020, Bryan has co-mediated estate and trust-related disputes, and has worked on matters at all level of court, including the Ontario Court of Appeal and Supreme Court of Canada. His articles have been featured in the Globe and Mail, and he regularly presents at continuing legal education programs. Bryan has also been named in Best Lawyers Ones to Watch since 2021, and he is a member of the Baycrest Foundation Professional Advisory Group and is a technical liaison of the Ontario Bar Association Elder Law Executive Committee. So a lot of really incredible achievements, Bryan, and thank you very much for joining on such a important topic as well. Financial abuse of older adults really is a growing problem with significant consequences for the person, for their family, and really society as a whole. So thank you for being part of such an important discussion and raising awareness. Now, I guess to hand it over to you, Bryan, we would really like to hear a little about yourself. Of course, being named as, in the best lawyers ones to watch since 2021 is such a remarkable experience. So can you just further elaborate a little on your professional, but also your personal journey leading you to where you are now at WEL Partners, including some of your work with the protection of the rights of older persons?
Absolutely. Good morning, Roxana. Good morning, everyone. And first, let me say thank you for having me here. It's a real pleasure, and it's nice to see all of you here this morning. Yeah, my experience with interacting with older adults, working with older adults, really started at a young age. I grew up in a small community in northern Ontario, about 10 hours north of Toronto, a town called Wawa. And when I say a small community, it was about in or around 3,000 people. And it was a close community, full of people who cared for one another, especially those older and more vulnerable folks who needed the help. And so, many were veterans of the Second World War, whom certainly I and younger members of the community looked up to. They were seen as role models, as pillars of the community. And so I guess I can say that my respect, my compassion for, interacting with and caring for older adults really started at quite a young age. And in concert with that, I also grew up in my parents' family funeral home. And so I lived in the funeral home and worked alongside my parents from a young age. And so, as everyone could imagine, that necessarily involved a lot of interactions with older adults who were, possibly at their most vulnerable stage, having just lost a loved one. And so I think I took a lot away from that and still rely on those experiences today because, navigating and coping with the trauma that accompanies death and the loss of a loved one is really similar to what I'm dealing with in my day-to-day practice now. That still forms a big part of my practice, given that I practice, estate litigation, but more and more, I find myself dealing with cases that are really the product of elder abuse, and in particular, financial elder abuse. And these are significant and have an incredibly detrimental impact on vulnerable older adults who, in most cases, have been preyed upon, isolated, abused, and so on. And so these cases are challenging, though often gratifying for me, because I have an opportunity to help right the wrong to the extent that I can, and assist these folks with navigating through the process. And which is not easy. If I'm involved in a matter that concerns financial elder abuse, it's typically in the context of a court proceeding, which is incredibly stressful and difficult to navigate for these folks, and expensive. And so, I think all throughout, though, I've had a keen interest in working with older adults, and doing the best I can to advocate for protections.
Thanks very much for that, Brian. And I think before we go into some of the more technical components of today in terms of questions, I just want to set the scene a little to a degree, and hear from you about what financial abuse really means to an extent. So, could you share with us some insights about the definition of financial abuse and the different forms or examples that you yourself have seen in your practice?
Sure. So here in Canada, our Canadian Department of Justice has reported that financial abuse is the most commonly reported type of abuse against older adults. And this, of course, it does not mean that it is not underreported, and I think we'll get to that in a moment. But let's consider first a definition of financial abuse, and I look to the definition by National Initiative for the Care of the Elderly, and that is an action or lack of action with respect to material possessions, funds, assets, property, or legal documents that is unauthorized or coerced, or a misuse of legal authority, or where someone tricks, threatens, or persuades older adults out of their money, property, or possessions. And I'll just say, unfortunately, there's not a day that goes by where I'm not dealing with some form of financial abuse on older adults. It comes in many forms, and it is ever evolving. If we consider for the moment the common types of perpetrators, the abusers, the people who are inflicting the abuse upon the older adult, often it's a person close to the victim. Adult children are common. Caregivers are common. Even spouses are common in the context of predatory marriages, and I'll come to that in a moment. Oftentimes, the relationship between the victim and the abuser is a relationship of some dependency. In other words, the victim is relying on the abuser or the perpetrator for care, support, assistance, sustenance, and so on. In my practice, we see financial abuse most often through the misuse of a power of attorney for property document, which, as we may know, is a legal document where a person gives someone else legal authority to make financial decisions on their behalf. And so that comes in a whole variety of different forms. Oftentimes, these documents are surreptitiously obtained. For example, here in Ontario, you don't need to go to a lawyer to make a power of attorney for property. There are standard forms available on the Minister of the Attorney General's website, which can be printed off and signed and presumptively valid. And so in often cases, those are weaponized and used to gain access to the older adult's property, to deplete their assets, transfer their assets, change beneficiary designations, and the like. We also see a fair amount of fraud, forgery, or extortion in terms of, again, fraudulently signing documents in order to gain access to someone's property. And a whole host of cases that concern undue influence or unduly pressuring an older adult to, say, sell property in order to realize the proceeds, which are then absconded with, invest or take out money in a certain way, pressure to make or change a will, sign documents that they don't understand, which I'll come to a bit in a moment, and give money to relatives, caregivers, or friends.
Thanks very much, Brian. And you mentioned power of attorney, this being a very common thing you've seen. So you've seen that in your practice.
Mhm.
How do you deal with that in those situations? Is it something that you notice right away, or is there a process? How does Well Partners and you, how do you deal with it?
It's difficult. I'll say that if it comes to me, that means that A, it has been discovered, and B, that there's somebody that wants to do something about this. So appreciate that this goes on each and every day, but it's not, within the view of the public. Typically, this is done behind closed doors where, the abuse is inflicted and nobody knows, nobody's the wiser. But if it does come to me, I can provide an example. I can speak to a case where there was an older adult in a long-term care facility. He was suffering from severe dementia. He's suspected that he was incapable with respect to the management of his property and personal care. An adult child came in, removed the older adult from the care facility, took him to a lawyer and had him sign a new will, to which he was the beneficiary to the exclusion of his spouse of 40 years, and a new power of attorney. He was then taken from the lawyer's office to a bank, at which point significant withdrawals of money were taken out of his accounts and absconded with. And so, that's a common example. And to the extent we get involved, typically it would be on behalf of the attorney named under the prior attorney document, or perhaps the spouse who has learned of this wrongdoing. And at which point the options are limited. We have remedies available to us in the common law in terms of a civil proceeding, which is what I would deal with ordinarily. And that involves commencing an application before the Superior Court of Justice here in Ontario, seeking to set aside this new power of attorney document for want of capacity or undue influence, seeking the removal of the attorney, seeking the interim suspension while we sort it all out, and appreciate that these are urgent, right? So if this document is being procured, it's being weaponized, it's being taken to the bank to deplete assets, such that perhaps the older vulnerable adult no longer has means to pay for things like their care, for their sustenance, and so on. These things need to move quite quickly. The issue with that is that since COVID, we have a real problem in our courts, and though they're trying the best they can, the courts are inundated with matters. They're short staffed, they're work.
Having trouble hearing you.
Sorry, Brian. I think we just slightly the
The volume, yes.
You still losing me?
We're not losing you. It's just the volume went down a little bit.
Is it okay now?
Perhaps if you could just speak up a tiny bit and closer to the computer, please, if that's all right.
Why don't we try 1 second? How is that? Is that better for everybody?
It is.
Oh, yes, now yes.
Thank you.
Always have a backup microphone. So what I was saying is that, I think the question is, what do we do? How do we go about it? How do we deal with it? It's before the court. And what I was saying is that though these matters are urgent, assets are being depleted such that there is harm being inflicted upon the older adult. It's typically a slow process, and it's incredibly difficult to navigate. But courts have a great amount of difficulty dealing with these types of issues too, because at the end of the day, it concerns a living person, and so the rights of the living person are always top of mind. The autonomy of that person is always top of mind. The representation of that person, notwithstanding if there's incapacity or not, is always top of mind to ensure that the process is a fair one and just for all concerned, especially the older and vulnerable adult. And I can go into this further later, but I think that's the start to your question.
No, thank you very much. And I know in the chat, Anna Maria posted a comment saying, using your voice is important. And I want to hear your thoughts on what some factors associated with higher risk of financial exploitation could be, and why perhaps, older adults may be at increased risk to a degree.
Sure. So this is a bit statistics heavy, but I think it's important. So what the statistics tell us is that our population is aging rapidly. And so in Canada, from 2011 to 2016, Canada registered the largest increase in the proportion of seniors since Confederation. In 2016, that was the first time that the census enumerated more seniors than children. And we are on track to see 1 in 4 Canadians being 65 years of age or older by 2031. And so with this longevity, which is great, it comes with an increase in the occurrence of medical issues affecting cognition, as well as related diseases and disorders such as dementia in varying types and degrees, delirium, delusional disorders, Alzheimer's, cognitive disorders, and other like conditions. It has been reported here that 1 in 11 Canadians over the age of 54 currently has Alzheimer's or related dementia, and dementia affects 20% of seniors by the age of 80 and well over 40% by the age of 90. There are a wide variety of disorders that affect capacity and increase an individual's susceptibility to being vulnerable, dependent, and unduly influenced. Other factors include normal aging, disorders such as depression, which are often untreated and undiagnosed, schizophrenia, bipolar disorder, psychotic disorders, delusions, debilitating illnesses, drug and alcohol abuse, and addiction. And these are the sorts of issues that unfortunately invite the opportunity for abuse, elder abuse and exploitation. Predatory marriages and abuse through powers of attorney and guardianships are just some examples of financial exploitation and abuse of older adults. And don't get me wrong, this isn't to say that financial abuse of older adults is limited to those who suffer from some variation of a cognitive disorder. That's not what I'm trying to say. But the statistics and our case law demonstrates that this is the most prevalent cohort. And so as that cohort continues to rise, there's more exposure to this type of financial abuse on the part of them.
Okay, thank you. And you mentioned elder abuse, and as a whole, it is very often referred to as just like a hidden epidemic due to the significant underreporting of it. So do you have perhaps any thoughts on how this relates to financial abuse in older adults, and why, to a degree, financial abuse can be underreported and then therefore sometimes unrecognized?
Absolutely. It is incredibly underreported. And even if, and I can get into this a bit more, even if it's known, even if there is clear examples of it, oftentimes you don't have a willing victim to come forward and deal with it. We get calls all the time from law enforcement, Toronto Police Service, who will say, well, I got a call from a financial advisor at a bank who says that so-and-so walked in with their caregiver and changed all of the beneficiary designations on their accounts from them alone to them and the caregiver jointly, which is a gigantic red flag. Everybody can recognize that. And is it abuse? I mean, it depends on the circumstances, but most likely, just by looking at it. So the bank, which good on them, calls the police and says, here's the circumstances, need some help. The police say, well, our hands are a bit tied because, what can we do about it? There's nobody coming to us doing any sort of formal report. It's not as if the older adult's coming to us and saying, well, she made me go to the bank and change all of these designations, or she misused and abused a power of attorney document to gain access to my finances. No. By all accounts, he appeared willing and walked into the bank and did it. So then the police will often call us because, they say this doesn't really rise to the level of criminal activity or any sort of criminal remedy that applies. So what can we do civilly? And it's kind of the same issue on our end, in that, who's the client for me? Who is coming to me and saying this is wrong, it needs to be fixed? It's certainly not the older adult who just transferred all the money to the caregiver. And in all circumstances, we can't assume that there are supportive family members who are keeping constant watch. For all we know, this person lives alone. Perhaps the spouse is predeceased. So there's really no oversight or protection. And even when it is flagged, the options available are quite limited. In terms of it being underreported, some of the common reasons for why, the victim feels a shame or embarrassment having been victimized. The victim is fearful of the perpetrator or has fear of the police or other authorities. As I mentioned before, the victim is dependent upon the perpetrator for physical well-being. That is incredibly common. Again, oftentimes it's the adult children who play a fundamental role in caring for the older adult. In hand with that, the older adult wants to protect the abuser, especially if it's a family member. And this is, it's unfortunate, but oftentimes the older adult will feel that an unhealthy relationship is better than no relationship at all. Fears that if, they pursue this in any way, shape, or form, they're going to lose contact with the person, even though they're abusive, is their only person. And then, of course, there are circumstances where the older adult may not even recognize the abuse. Perhaps they lack the requisite capacity to recognize the abuse. They may not have the physical ability to report, which I've seen time and time again, especially people who are immobile. They're targeted in a facility. They're asked to sign. It's not even clear if they actually signed the document or not. But nevertheless, their name appears on a power of attorney document, which is subsequently waltzed into the bank and used to gain access to all the finances. And this just goes on and on. You can imagine that there are a whole host of circumstances where, it's going to prevent these sorts of things from getting the attention of authorities or lawyers or the like. And I think it's also important too. And there's a general, and this isn't a criticism, it's just a general lack of awareness among all levels in, say, financial institutions, law enforcement, care facilities, and it goes on, and especially on the ground level. So, oftentimes this happens at the local branch in the local bank branch in a small town where, so-and-so is waltzed in with whomever. This document is produced and say, I'm the attorney, we need to do this, that, and the other. And, the older adult, for whatever reason, says, yeah, let's do it, either because they're being unduly influenced or they lack the requisite capacity, or otherwise they're being coerced. And, the teller at the bank, what are they supposed to do? If they haven't been educated on what the red flags are, what the warning signs are, perhaps this looks all above board. And so, these things have just been kind of rubber stamped, over the years. And, we've really gone out of our way, and not just me and my firm, but the practitioners in our bar to, ensure that we're educating and making these institutions aware at all levels. I do talks such as these for financial institutions, for care facilities, for law enforcement. I think the more we spread the word and identify the red flags and make sure that they're at the top of everybody's mind, the more successful we'll be go forward in getting these types of things reported. Yeah. Another issue, and this is with respect, I guess, to the involvement of law enforcement, is that these types of issues are typically mischaracterized. So, if the police get a call and say that, so-and-so surreptitiously obtained a power of attorney document and used it to deplete my assets or transfer my assets or gain some sort of financial advantage to my detriment. Traditionally, that has been, viewed as a civil matter, such that the police, law enforcement wouldn't often pursue it. And that's, notwithstanding the fact that there are provisions in our criminal code that can be applicable. Section 331 of Canada's criminal code is labeled theft by a person holding power of attorney. That section is incredibly underapplied. If you do some research and note it up, there are only a handful of cases where it's actually been applied and prosecuted. And so again, through awareness and education, and we do a lot of it. We speak at the police college, we speak at the Toronto Police Service, and we have a good relationship. They have a vulnerable persons unit, which is fantastic. We really try and get the word out and explain to these folks how we can play a role in how these things get reported and raised. And again, I'll just reiterate, because this perhaps I think is the most frustrating on my end. It's just you have a willing victim, and even if they're not so willing, it's just not readily apparent. It's somebody being taken advantage of. Again, it's in a relationship of dependency where the person will do whatever they're being told to do for whatever reason, many of which I've mentioned. They rely on the person, they're afraid of being alone. It's a child, they're afraid to go after their child and the like. So it's really an uphill battle in terms of being in a position to identify that this type of abuse and for it to ultimately get reported.
Well, thanks very much, Brian. And we have a lot of questions and comments in the chat, so I'm just gonna turn to that a little bit. And the first one is from Mr. Shmuel Yerushalmi. He is a regular at our Global Cafe with always great insights. And his question is regarding the role of governments and authorities in effective preventative financial abuse strategies against older adults, but maybe we can also shift this question to also reflect policies. So how can policies also best respond to and support older adults who've been impacted by financial exploitation?
It's a good question. It's an impossible question to answer, because what is the role of governance in these policies? They're fundamental, of course they are, in terms of how we identify and try and prevent these instances of financial abuse. From my perspective, and I always have to give my head a shake, because appreciate that I deal with the worst of the worst, right? Nothing that I deal with in the day-to-day as it relates to financial abuse of older adults is pleasant. It's typically horrendous, and it's gotten to the level where lawyers and courts and perhaps law enforcement is involved. And so I always find myself in a position where I'm saying we need to do better to come up with some policy. We need to lobby, which we do. We're constantly working with our Minister, the Attorney General, to try and tweak legislation, introduce new legislation that not only gives us the tools to assist these folks, but also to try and prevent it at first instance. But so last week I was at the Canadian Elder Law Conference in Vancouver. I was speaking on a panel, but there were some great advocates out there, advocates for older adults, but advocating for them to preserve their autonomy and be independent. In other words, why once we hit the age 65 do certain rights start getting peeled away? Why are we even using the age 65 anymore? One of the foremost experts in capacity here in Canada, Dr. Ken Schulman, opened his talk by saying 65 is no longer a relevant age. The developments and where we're at now, he's like 75 is late middle age. So why are we labeling people who are 65 and older as being these older, compromised, vulnerable adults? And so coming back to the question, it's incredibly important that these policies get done, but it's a tremendous balancing act, right? Because from my perspective, we need things. We need checks and balances in place that are going to protect these folks and prevent this type of abuse. But those policies and those things can't go so far as to interfere with or diminish the autonomy and identity of older adults. And so I think that's the real delicate balance that we're all trying to work with, we're all trying to achieve. It's just it's a really difficult one to come to, and there's no clear answer. There's middle ground, but is it going to totally do away with this type of abuse? I don't think so. And that it can't go so far as to infringe on the rights of older adults. And so it's a struggle we're dealing with on a daily basis.
Yeah. No, thank you for that. I would like to also ask Miss Jane Morrison. I see you posted a question in the chat. If you don't mind unmuting to posing your question to Bryan.
Sure. I'm glad you didn't ask me to put on the video because I'm still in my pajamas. So I was wondering, in your opinion, what are some needed changes around power of attorney that could help prevent financial abuse? In particular, are you aware of best practices in some other Canadian jurisdictions? I was at a retirement workshop recently where they're talking about differences between Ontario and Quebec, for example. At Quebec, you had to absolutely keep track of expenses. In Ontario, it's like, that'd be nice, but I don't know. Just what could be done to better control power of attorney?
Yeah. So I'll start off by saying this: the legislation, the regime that governs the role of an attorney, and we'll focus on an attorney for property because that's what we're dealing with here, is quite good in Ontario. Our Substitute Decisions Act sets out all of the duties and obligations that an attorney is supposed to do. At first instance, an attorney for property is a fiduciary. They are accountable by law to the grantor of the power of attorney document. In the ordinary course, appreciate that the checks and balances that are in place, they work to the extent that an attorney doesn't act appropriately, is in breach of their fiduciary duties and obligations owed to the grantor of the document. Well, then there are remedies that can be pursued against that attorney, such as their removal. You can compel them to pass their accounts, which is what you're referring to. They absolutely have to keep records here in Ontario, like complete records, every dollar in, every dollar out. To the extent that they can't do that, they can't explain away what they've done if there's money missing. They attract both professional and personal liability for what they do. But that's in the ordinary course. That doesn't really contemplate when one of these documents is just surreptitiously obtained and weaponized and marched into a bank and used to deplete assets, because at that point, that person doesn't particularly care what their duties are or what they aren't. They have one goal in mind, which is to get their hands on the money. And so those same remedies apply to those people nevertheless. And so in my world, look, I'm a civil lawyer. I don't deal in criminal matters. I'm stuck with the remedies that are available to me by way of legislation and in the common law. And much of that is still applicable, and it can be used in a way to get the money back to the extent it's at all possible. So just to provide an example, in that example I referenced earlier, where the older adult was taken from the care home by the adult child, marched into a lawyer's office, power of attorney document was obtained, subsequently taken to the bank, large withdrawals of cash, older adult gets dropped back off at the home, and adult child takes off. The court application would be commenced as it gets that older adult child in his capacity as an attorney, given that, for better or for worse, he's signed himself up for the job. And so all of those remedies apply. It would seek not only his removal or his suspension as an attorney, and also a determination of the validity of the document he or she's relying on. But it would also seek an accounting and restitution for any monies dissipated. And so all of that still exists. They're going to be governed by that regime no matter what. It gets complicated. And difficult because obviously there's not an ounce of good faith about what these people are doing, right? They're doing this for one reason, which is for financial gain. The difficult part is trying to get the money back. Notwithstanding, you get a court order finding that this person acted improperly, that they breached, that document was invalid, that what they did was completely wrong. At the end of the day, you still got to try and get the money back, and that involves a whole host of other civil remedies, such as tracing. And at the end of the day, if it's been dissipated, it's been dissipated. It's unfortunate, but that's just the way it goes. But look, I think there's a regime that works with respect to power of attorney and the rules and that apply. The problem I'm seeing is just that there's really no control over how these power of attorney documents come about. And I think that's really the issue. The fact that you can just print these things off the internet, and I'm not saying that's all bad. Like it's I get that it's a fundamental access to justice issue. If you got to force somebody to go sit down in front of a lawyer and pay a pile of money to get a power of attorney document done, I get it. But the fact of the matter is that you can just print these things off the internet, and they're just presumptively valid, and who knows the circumstances behind how that document came to be, and that's not being scrutinized necessarily until it's too late.
No, thank you very much, Brian, and thank you, Jane, for that great question. Next, I would like to ask Dr. Cynthia Stewart. You posed a question in the chat as well, if you don't mind unmuting to speak with Brian.
Oh, Brian, I can't imagine the stress level of your job. But in the case you just talked about, somebody's executed a power of attorney, and that may be oftentimes relative, brings them in, defining who the client really is. Because if that person holds the power of attorney, it's that person is your client, right? And I just sometimes wonder how that really gets established when it's for the good to take care of. I know it gets very complicated in dementia cases, but as I listen to your cases this morning, I just wonder if any elder law attorneys or practices have ever thought of employing social workers in their practice with that skill set to complement the legal skill set.
Right. So just I just want to make sure I understand. So are you speaking in respect of my practice? So in other words, the wrong has been done and I'm dealing with perhaps the older adults in terms of dealing with that wrong, or are you speaking to the lawyer who's preparing the power of attorney document?
No, I was talking about, the cases, your law firm, and then you mentioned you have an elder law network in Canada, as we do in the States too. Just specifically for your law firm, and then do you know of any, and it would fall probably in elder law attorneys' offices or practices, group practices, that any of them might employ a social worker, maybe not full-time, but have on retainer to work on this?
Absolutely, and that's a great question, and it's becoming more and more prevalent, I will say. So typically speaking, you won't see them on staff at a law firm, but quite often we reach out to those professionals for a whole host of reasons. In the context of the litigation, appreciate that often the older adult has issues with declining cognition and capacity, and they have needs that might not be met on account of the actions or inactions of the abuser or others. And so yes, social workers are eagerly sought out to assist us with identifying those needs and helping us navigate through the process with these individuals. We also deal with occupational therapists quite often to assist us with assessing those needs and determining what needs aren't being met. And then of course, medical professionals as well to assist us with the capacity issues, assessing capacity and whatnot. So yeah, absolutely. I think, and I don't quote me on this, but I'm quite sure that there's actually joint program here in Ontario. It's a law degree and social worker degree together, which is actually a fantastic idea. Of course, when you go to law school and you don't know anything, and you don't know what your career trajectory looks like. All you want is a job. You're not quite sure what the job looks like. That wouldn't occur to you as being something that would be an incredible experience and opportunity that would help you go forward in this practice area. But I really should look into the status of that program, because it's a fantastic idea. It's a fantastic idea, and to have that skill set in addition to being able to navigate the law, I think is fundamental in this area.
Thank you.
Well, thank you both very much. And returning back to the chat, I see Miss Anna Maria Cruz, you've made several comments. Would you like to speak a little on some of your comments, perhaps?
Okay, sure. Thank you very much. Well, my concern is with the increased financial abuse for elderly population, especially ethnocultural seniors. Some because have lost the sight, or others because difficult mobility. And it's mainly coming from the children. I cannot say that it does not happen also with people who assist them, and with the banking cards. And they take money out of their account without any control. And even I have witnesses the case in a family. The senior was abroad. I think the child, one of the children living in this country, sent the person abroad because he thought that he was going to die. He didn't die. And I became aware of the tremendous and large financial abuse, but there is not much to protect. And the worst thing, the worst case is that the elder do not provide any information for the police, because they are afraid. They are the victims and they are afraid. So it's silent. So the person working in the community trying to help them as much as we can, we are unable to do anything, because if the person, the victim, does not speak up, so what can be done? Because I think the banks somehow, should have a red flag on the accounts of seniors to monitor to a certain extent. I think that will be a great protection to monitor those accounts, how they are moving those accounts, and inquire about that. Thank you.
Those are, no, it's a good point. And I sort of referenced that circumstance earlier. You have to some extent a willing victim, or somebody who doesn't want to come forward for a whole host of reasons. Again, not many parents want to sue their kids, regardless of what they've done, or they're incapable of doing it, either cognitively or otherwise. And you identify a key issue in that, notwithstanding that, the abuse is still occurring.
Yeah.
And how do you deal with it? And yes, it's a good point to say that, there should be some obligation on the financial institution to monitor and oversee and scrutinize, which goes some way to at least identifying the abuse, the potential abuse. But even then, where do you go from there? Where do you go from there? Like, the bank, I don't think is going to have any ability to pursue or otherwise prosecute it. All they can do is identify it. And so it's the older adult's property. It's really for them or their representative, be it an attorney or otherwise, depending on where you are, to pursue. And if it's not getting done, then it unfortunately it just remains silent, which is the problem. But it's tricky to navigate because, and I don't want to keep beating this one over the head, but you run into issues when you come up with these sorts of policies on the part of the financial institutions. So if we're going to say that, financial institution has to oversee and scrutinize every transaction for persons over the age of 65.
Yeah.
I mean, that causes a bit of a problem too, right? In terms of the freedom and autonomy and the rights of the person. And so again, we're back to that incredibly difficult and delicate balance where,
If you allow me 10 seconds, please, I think it's the role of the government to protect us seniors in the government, because the crime exists. The government legislates, so the bank institutions have the ability to do so, but it's the role of the government.
Yeah.
Because at this moment, the crimes are happening and we are doing nothing because there is nothing that we can do. So we cannot remain silent and indifferent. Thank you.
No, thank you very much, Anna Maria. And perhaps, Brian, one thing that we could talk about is just some preventative strategies that would also, to a degree, speak to how this can be deterred slightly. So some preventative strategies and some tips to prevent financial abuse.
There's no perfect answer. There's no formula here that if you follow it, you're going to be able to prevent it. Unfortunately, I think it's on all of us, not just lawyers, not just medical professionals, not just financial advisors, but I think society as a whole, to recognize this as a fundamental issue globally. Not just here, not just in the States, everywhere. It's on all of us to know the red flags. I reviewed some of them earlier. Know the warning signs, and if so, you may be in a position to try and prevent it before it takes place. I think communication is key. Check in with those who are vulnerable and susceptible. Are they exhibiting any of the warning signs? Has there been an obvious decline in cognitive ability? Are they being isolated? Have their living circumstances changed? If so, communicate, reach out to the extent that you need to get help or report it or get a wellness check. Whatever needs to get done, I think it needs to get done. I think it's a positive obligation on all of us to do it. If you suspect it, report it to law enforcement. Get legal advice. As I've reviewed here today, there are options and ways in which victims of elder abuse can pursue remedies in both the civil and criminal context. And be familiar with the resources available. The IFA is a fantastic one, and there are other entities and organizations that really drill down on these issues, focus on these issues, and can assist. And I think just more on a high level, and I think we've really started to recognize it here in Canada. The more I go to these conferences concerning elder law and abuse, I think traditionally we all worked in our silos. Lawyers worked with lawyers, and doctors worked with doctors, and banks worked with banks, and there was really no collaboration, no cohesion, no communication as between them. And I think that the more prevalent that these issues have become have really knocked down those barriers between those entities, between those institutions, such that more and more we're finding ourselves working together with all of us, trying to get ahead of these issues, trying to put a stop to these issues, trying to prevent these issues go forward.
No, thank you very much, Brian. Interdisciplinary collaboration is always very effective. I see Indu Gambhir, you have your hand raised. Would you like to pose a question to Brian?
I think it's more than a question. As a medical doctor, I have seen older adults come and want to give something to their caregiver, but they are afraid that something will not be given to their caregiver after they're gone. And I had a case, a very wealthy man, and he wanted, so I said, if you want to change anything, you come and see me. I will send you to a psychiatrist to see that you are competent. And then the same day, make appointment with your lawyer to see whatever you want to give to the caregiver, and I'll keep a note that you have. And that happened after he passed away. And his reason was, these kids only come to see me only Christmas and Thanksgiving or other, and send a card, but they never take care of me. And this is the family who's taking care of me. So it happened. After he passed away, the heirs did go against the caregiver. So there is another side to it too, that sometime there should be a process that if some older adult want to give something to a caregiver, it is properly done.
And so don't get me wrong. And I use the example of the caregiver because it's just a common example of financial abuse. It's a common perpetrator that we see. But that's not to say that in every instance, in every circumstance, that someone wanting to leave something to a caregiver for what they've done, the companionship that they've offered, is wrong. And so once again, you're in that delicate balance, right? But the scenario you just raised is also a large part of my practice, but more so in the context of estate litigation. And so oftentimes you see that this very circumstance where an older adult will change their will at a later stage of their life to leave something to those that cared for and provided for them. And of course, that is scrutinized after death by those who thought they ought to have been entitled to all, whether they be children or otherwise. And that gives rise to a whole host of disputes, which are incredibly difficult to navigate. Why? Because by the time you get to that point, the person who chose to do that, the person who chose to change their will and leave assets to a certain person over another, is no longer there to speak to it or justify why they did it. And I think that the steps that you outlined, given that it sounds like there was an assessment of capacity to determine whether or not he was capable of, or he or she was capable of making that change, that it was well documented, that's helpful in terms of justifying and ultimately shutting down any sort of claims and scrutiny that would flow to the estate. But appreciate too that that's not always the circumstance, right? Like that's the sunshine and rainbows version of this story. That's how I like to say it. But other instances appreciate that the financial abuse doesn't actually come to light until after death, and you have that circumstance where the will has been fundamentally changed to favor a stranger, or sorry, a caregiver who by all accounts is a stranger to the family unit, and which serves to disinherit the kids or the family who would have expected to inherit. And that's you got to deal with those suspicious circumstances and really unravel and unpack and figure out what the justification was for the change. Was the person did they have the requisite testamentary capacity to make that change to a will? Were they unduly influenced by the caregiver? Were they coerced by the caregiver to make that change? In other words, was the caregiver saying, I'm not going to care for you anymore unless you make this change to your will? It happens. We see it all the time. It comes out in the evidence. So, I'm gonna say that it's definitely a case by case basis. I've seen it where everything was completely above board, just as you had mentioned. The person wanted to do it; they were capable of doing it. It made sense in the circumstances. It's documented, open and shut. It's done. But I also see a handful of the other ones where it's quite clear that the change wasn't the product of the person's free mind, but rather they were either incapable of making the change or being coerced into making that change in favor of the caregiver to the detriment of others. So